Most people who sign a non-compete agreement scoff at it and just assume it won't be enforced. Florida has a different opinion. Like a lot of other states, Florida courts don't just throw out overbroad non-competes. They trim them down and they enforce what's left. Whether you're the employer trying to protect your business or the executive trying to leave and get another job, the rules here are not what most people expect. Hey there, my name's Alex Castro. I'm a labor and employment attorney with AXC Legal based out of Fort Lauderdale, Florida. Everything that we're going to talk about, it's just general information, it's not legal advice. If it sounds like something that you're dealing with, make sure you consult with a qualified attorney in your jurisdiction to actually talk through your situation and how your situation should be addressed. Companies looking to protect their business often relish in the fact that Florida is one of the most employer-friendly non-compete states in the country by statute, maybe even the most friendly. But even though the state is pretty friendly toward them, it doesn't mean that they're a free pass. Non-competes as a whole are still really disfavored by the law because our free market likes when people move around. So all that said, in order for a non-compete to actually be enforceable, there's a lot of things that actually go into it. At a really high level, a company looking to enforce a non-compete agreement needs to be able to demonstrate a legitimate business interest that they're trying to protect and that it's reasonable in time and geographic scope. Typically, we're talking about trade secrets, substantial relationships with customers, specialized training, not generic training, specialized training. If an employee who is privy to your company's trade secrets can now walk on down next door and share them with your competitor, your company might just be tanked. Or if your departing employee has really solid relationships with certain key customers of the business, well, what happens when that person leaves and the customers now follow them? I'm not talking about just generic onboarding where an employee learns about how your systems work. That's going to happen at any company, and it's not the type of thing that gets enforced for a non-compete. Remember, on the opposite end of this is you are prohibiting somebody from earning a living in their chosen profession, and courts take that very seriously. A non-compete still has to be reasonable in scope. So make sure you're not doling out non-competes willy-nilly, or that you're trying to enforce them against people who really aren't going to be a threat to your company's livelihood. And even though technically that's just a temporary injunction and there's still more of the lawsuit to go, most restrictive covenant cases like these, they're decided at the temporary injunction phase, and whoever wins there just basically wins the case. That said, if you've got something you really need to protect, or there's really a true urgency to the business, or a true threat of disclosure, or losing a key customer account, you've got the temporary injunction process to go to court and ask for basically an emergency petition to say, hey court, I need you to put a pause on this. I'm not saying to never issue a non-compete. I'm saying to think carefully about whether or not a non-compete is the solution to the problem you're trying to solve. Oftentimes, what companies are most concerned about with non-compete clauses is losing key customer accounts and an employee divulging trade secrets or other confidential information. Those two things typically can be solved through a non-solicitation agreement or a strong confidentiality agreement. And if you're an executive who's been presented with a non-compete agreement, take it seriously. Either way, there's likely going to be an exit of some sort from this company, and you are going to wish that you had negotiated this non-compete early before you did. Some of the most successful executives I see pre-negotiate exception clauses into their non-competes, where it says, sure, okay, I won't compete, and we still have some broad language. Or sometimes a company's got a really clear idea about who are the competitors that they don't want employees going to when everything is said and done. A lot of non-compete agreements for executives often have an addendum at the end that specifically lists certain companies that are covered by that non-compete. Negotiate those. See if you can get those in writing so that at the end of this discussion, you actually have clarity on what is prohibited and what is not. If you've done things right, you've probably also pre-negotiated your severance in your employment agreement or in a separate non-compete agreement. See if you can tie those together so that you are at least still earning an income while you are prohibited from working. Often, you're trying to go to a new company, a company that really wants you, that views you as an asset to whatever their strategy is. So see how you can get your new employer on board here. Maybe they'll cover your legal fees for you because they want you so bad that they're willing to fight for you. Or maybe you can put the legal departments between these two companies and have them talk directly to each other to see if they can work out a solution that allows you to move on while letting the businesses stay comfortable that there's not going to be an issue here with you moving on. And if anything we've talked about today sounds like something you're struggling with or that you need support with, click the link below to schedule a consultation with me.